management. They both have a wealth of experience. Kenny currently runs another company that also provides consulting in this area, and he is the former chief legal officer in Asia of various companies, including Geely, Kodak, PepsiCo, and probably 3 or 4 others. If you check out his bio, he has a wealth of experience. And he's joined today with his co-founder, Bill, who also has a ton of experience beginning his career as a chemist and then moving on to try to get away from chemistry to everything but chemistry. He was associated at a couple firms, including Sherman Sterling and as well Paul Hastings. And he also had a lead management role in operations at PepsiCo. Perhaps that's how you two met. I don't know that yet. And he has had a wealth of experience in the last few years consulting with legal services providers. So without further ado, I turn it over to them. Thank you for being here.
Thanks, Michelle. Since this is lunchtime, I'm going to play you a song first, and I apologize. It will be, because of the interest of time, we'll have to skip the first stanza, but we'll just get this started first. Let me know, raise your hand if you don't hear it, right?
But then you don't pay a fee. Motions cost money, but you think they should be free. You cry, oh why is my bill so high? My bill so high. Well, I can't clarify. If you come to my office or call my phone, I'm billing time. You stop me at parties to wine and bowl. I'm billing time. If I think of you when I am alone.
This is my favorite part.
I'm billing time. If you're late for appointments, I will be waiting. I'm billing time. Still billing time. I'm billing time.
All right, thanks. That's it.
That's the full presentation. So we are here to talk to you guys about the 5 forces that are changing the legal industry. And there's no necessary magic to the idea of there being 5 forces. And to be fair, when you're looking at these things, all of these interplay with one another. So don't overstate how siloed these things are, because they do all interact. But for the sake of putting some framework around things, we decided there's 5 forces. So the first one I wanted to talk about is technology. And I've put a lot of resources up there about legal technology. I'm not necessarily endorsing any of these publications or organizations, but I do think that if you're interested in this topic, this is a good place to start to learn a little bit more about it. So looking at legal technology, I would describe this in 2 major buckets. One would be traditional technology that's now starting to infiltrate its way into the practice of law. And then what gets a lot of buzz but is yet to deliver perhaps as much results is more the emerging technologies. So when I say traditional, I'm talking about technology that exists, it's established, it's functional, and it's deployed to the general population on a regular basis. And within that, I've kind of got 3 buckets. So one is people are starting to leverage technology to problems that are unique to the practice of law. And that is the stand-in app is one of the things I wanted to highlight to you. And that's what's over on the left side of the slide. And full disclosure, this was rolled out by a good friend of mine, Peter Carianis, so I'm somewhat inclined and biased to this as well. What stand-in does is it doesn't actually address legal questions, but it addresses a problem that legal practitioners have. And that is a lot of small and solo criminal defense practitioners will be on they usually have practices that span multiple courthouses, and they may be on the way to one courthouse when they get a call from another client for an arraignment or a bail hearing, and they need to be at another courthouse. And it's a non-substantive hearing, but they can't be in two places at once. So they'll go down a call list and try to figure out who they know that could kind of stand in for them for the basic procedural hearing. Stand-in takes the technology that anybody that's used Uber already knows about and applies it to this problem where now you can log into this app, see who is there, what they would charge for a quick stand-in, and because of geolocation, you already know who's already in the courthouse that you need them at. So he's already rolled this out in Toronto and Detroit, and I know he's got plans to expand this to Chicago, New York, DC, Boston. So we'll see where it goes, but it's an interesting approach to a pure practice-oriented problem. I think that the second area is people are increasingly leveraging technology to the way that law is managed. So a traditional law firm is very, very focused on what I would call the easy metrics or the Citigroup metrics, which oftentimes focus on high-level or top-line revenue. But increasingly, there's a focus to dive beneath the hood and look at profitability, look at resource allocation, and you're seeing technology, whether it is SharePoint or something even as basic as Excel, but being leveraged to dive in and look beneath the hood into the operations of these businesses. And I think that that will increase. You're seeing a lot of activity with vendors in this spaces, whether it's Sky Analytics or Redwood or some of these other players, but they're bringing more technology and management dashboards and tools to legal practice. And then the third area would be, in the traditional sense, would be how legal services are being delivered. So this may be legal project management tools, which I don't know if you guys have any familiarity with, but there's a kind of this idea of looking at law as a process and using technology to supplement and support that process. So there's a few innovators in that field that are bringing offerings up. Elevate's Kale comes to mind, as well as leveraging things as simple as Excel to bring practice toolkits to the practice. And I want to leave room for Q&A, so I'm happy to go back and flesh that out. But the idea of a lawyer getting a project, starting in the middle, working in this iterative process, which is very traditional, is now starting to break down, and they're leveraging technology to continue the iterative process, but make it a bit more structured and get visibility into how we're delivering legal services. Then the area that everybody's really interested in is the emerging technologies. So I'm just going to go way too fast, but just highlight a few things. One, in the e-discovery space, which particularly in US litigation is an extraordinarily expensive venture and is only getting more so, would be two technologies, one being predictive coding, this idea of machine learning where you can train an algorithm to pre-sort or even pre-identify which documents are relevant, which documents are responsive, which documents are privileged, and semi or completely automate the process. Another would be language-based analytics, which is different from predictive coding in that with predictive coding, you're starting with an algorithm that a human being trains. Language-based analytics starts with just taking your entire data set, seeing which words or phrases kind of cluster together, having a human being go in and say, well, these clusters are actually interesting and potentially responsive, whereas other clusters are not, and using that to form the algorithm in the first instance. So kind of the inverse of what predictive coding does. Both of those in the e-discovery space primarily, but it doesn't take a tremendous leap of imagination to see how that could be applied to the big data problems that corporations face in business applications and compliance, the corporate universe in and of itself, as well as within law firms and data mining. And then the one that probably gets the most headlines, artificial intelligence. I don't know if you guys are, have read about this, but Watson, IBM's engine, went to law school. The second place winner in the contest from University of Toronto, Ross, has been picked up by the Y Combinator, and it was the first acquisition of Denton's Next Law Labs. And they're using this, to take natural language legal questions like, can I fire an employee for cause in Alabama that is only suspected of stealing without, definitive proof that they stole? And going in there, looking at all of the resources that are out there, whether it is regulations, statutes, case law, etc., and spitting back out both an answer and a confidence interval in terms of how confident they are. I think that we're a bit of a ways away from a fully AI level system, but it is exciting and interesting to see this activity and to think about the ways that this may change the future. This one's you, Ken.
Okay, thanks. When Bill and I put this together and we're thinking through 5 forces, right? So someone might say, well, big data, it's sort of technology. Why didn't we put it together? We could, but we decided to spread out because there's a lot of things to say about big data. The least of which is the analogy to what young people do, and they don't know what they're doing and things like that, but everybody wants to talk about it. So there's big data, there's big data. In many ways, there's anecdotal or anecdata versus big data, and that's let's say what is this about? This is going to change the way we approach legal issues and problems, or just anybody's problems, because things are going to start blurring between what is a legal problem and what is not a legal problem. It's also going to change the way we solve these problems, because there is a term called Internet of Things, and I think someone probably might have used this term before, but I like to always refer to this as the Internet of Legal Things. From many years of being in-house, I may have drunk the Kool-Aid and may have been part of a business organization, want to think about it from product development all the way down through after-sales service, and then your broader community and other capital managements. That is, how do you solve a problem that is partially legal and not fully legal, and how do you get enough data to work with? Because come to think of it, what lawyers do, right? We were taught, at least, we learned the law, I hope. We were taught, hopefully, in school and in your first jobs and your internships and all that, learn how to identify issues. And then you apply this wonderful knowledge of law combined with the facts. But what are the facts? Who are the facts? And I always refer to all the litigators in the room, Bill being one of them. Were you a litigator, Michelle? Anyway, one of my former mentors said litigators are lawyers. We go to them to check out what? To check out the odds in this jurisdiction, in front of this jury, in this jurisdiction at least, in other jurisdiction, in front of a certain judge and a certain Communist Party member panel. But you go, you know the odds, you know how to navigate this, and you know what to say, what not to say, and what policy flag to pull up. But also in this jurisdiction, at least from the movies that I watch, A Few Good Men, Legal Eagles, they marshal the facts like there's no tomorrow. They really go and find out by hook and by crook. You go to Guantanamo Bay and find your facts, and you goose the guy to make him say the facts, whatever it is. I think in our world, the problem is, why are we talking about this? That's simply because we know the world is generating each year roughly, by something I read, the amount of data that the world has generated since the beginning of, I guess, the first written word. And by the simple reality of, I know we're sitting in a room of very, very high power thinkers and people who know how to think, but we do have limitations on speed. We do have limitations on memory, comparing to some of these gadgets in our pockets right nowadays. And we do have limitation as a group in working with consistencies. And we do make mistakes. I'm sorry, at least I do. And so we have to, each of us have to walk around and operate like this a little bit in the future. One of my college professors a long time ago, back in, if I should date myself, in the 80s, said that we'll be having something implanted with us. Our thumb's going to evolve to be huge, almost as big as our head. So things like that. So it's a lot about something you have to deal with it. And as some ways that we're doing e-discovery and all this, we're winners already. People are already doing it because they screen off the first year, second year associate screening, right? And they do some of the escalations. Now, for me, as an in-house angle, this is actually an important thing because in order for all of us who have a lot of passion to do preventive law, which is not necessarily the most attractive thing for most people who want to be the savior, who solve the problem at the downhill of the cliff, borrowing something from Richard Susskind. We like to solve it here, and I have seen it so many times. Why don't we solve it at the table rather than down there? And in order to solve it, you have to work with your organization. Most consumers of law today are corporate and businesses, and that's where the depth of our experience has been. But the same thing applies to public law. You have to go and figure out what your customers and your consumers' problem is and solve it up front. It's much easier to do it upstream than downstream. The question, of course, is always measurement. That's a whole different course that Michelle and her many friends would teach here or one of the places. I won't belabor that point. Just one last thing about big data. It's also about quantification. We think of risks. First of all, we think of risk, and we don't think about risk. We cannot think of risk in a context. We have to think about risk and ops. One of my best bosses, business guy, I learned a lot of my stuff from him. It's risk and ops. And you multiply the probability. It's very simple. You multiply probability at the very top level with something likelihood of the consequence, and then you go through all these permutations of what's going on, and that's something fun for us to do. But unless you can start really quantify it, you can't really talk to your clients, your CEO. Why are you doing this? Why am I bothering with this? And that's something I think I'm trying to, what I'm saying here is nothing new, but I think that there's something to take away about that. It's about really how we go and work with these data, more granular rather than at the high level, because that's where the good stuff is.
Yeah, so with apologies to Kenny, who actually has training in economics, I misuse this term. This is not true macroeconomics because it is market focused, but there are bigger forces at play in the business of law that are changing the way legal services are procured, delivered, and sourced. So the first big one, and it's why I put a basic supply and demand curve up there, is that supply is outstripping demand right now. And there's any number of sources out there, law school tuition bubble and whatnot, and Above the Law covers this all the time. But there's when you look at the legal sector as a whole, there's a segment that is way over-serviced, and that's what I'm focused on, and that's the corporate legal vertical. And speaking at Harvard Law School, most of you will probably go into big law practices, and most of you will service corporate clients. Many of you will ultimately end up in-house. And in this area, there are more graduates that are targeting that segment of the legal services market right now than there is demand. And that's causing it to be increasingly a buyer's market. And increasingly, clients, and I've seen this because I've done this work for clients, are waking up to their own purchasing power, which is changing the way that they interact with and procure outside counsel. The old model of long-term institutional relationships increasingly is crumbling. I think that the second major difference, and this is something that's been kind of a long time coming, but right now with the pendulum that swings back and forth, the pendulum is swinging more and more in-house. in terms of large legal departments are actually ramping up their in-house legal function. The proportion of their legal spend that is dedicated to in-house resources versus external counsel resources is growing. And the easiest way to think about that is, I'm going to use like real ballpark numbers, but just from the New York City market. If you think about a mid-level, although right now in some law firms it's more juniors, they're charging an hourly rate of about $500. 2,000 hours at $500 is $1 million. So if I'm in-house and I can identify 2,000 hours of work that I am outsourcing, I can get somebody who is senior associate level to junior partner level for around all in, and that's not just comp, but that's comp, ben, G&A, and T&E, for about $250,000. So I got a 4-to-1 differential right there. If I can hire somebody as a full-time equivalent, have them twiddle their thumbs 50% of the time they're in the office, I'm still saving $500,000 on outside counsel spend. And that's the kind of decision calculus that's being talked about in-house increasingly, which is causing them to look internally at their legal spend and their legal deployment and saying, whoa, if I've got supply outstripping demand and I've got all of these lawyers that are, coming of age and are not making partner because the demand is not there, that's another interplay of the buyer's market that we're seeing right now. Caveat, we've seen this before and it's swung the other way. I don't know how long this trend will last, but I think right now it plays into the picture. And then the last sort of big factor that I see going on in the market right now is geographic flattening. And this also plays a little bit into unbundling, that I'm just going to asterisk that for right now because Kenny will talk more about that in a bit. But when you look at the billable hour, which is still the predominant the predominant billing model for corporate legal services, I would say that there's 4 basic pillars that it stands upon. Traditionally, there's the 5th one, but I'll explain why I think there's only 4. And that is years of experience, geography, practice area, and size of the firm. And if you know those 4 factors, you can actually figure out what this person is going to charge in actually a very, very narrow band. Because we are now able to say, well, why do we need to have that work done by an associate in a high-cost jurisdiction like Chicago, New York, DC, LA, and instead we could take that same work and leveraging the fact that we now all are connected with all of our electronic leashes and various technology tools for collaboration across time zones and geographies. Why can't we source that to a lower cost jurisdiction, whether that's West Virginia or Tennessee or North Dakota or Montana and things like that? And as clients also become more sophisticated in being able to say, well, this segment or slice of work, and this is the unbundling aspect, doesn't need to be done here. Let's ship that over there. They may be, they may be asking the firms to do that themselves. And you have seen some big law shops open up sort of onshore near sourcing operations to take advantage of this rate arbitrage, or they're actually segmenting the work out to other service providers. Yeah.
Okay, thanks. Well, we work a lot in international contexts, and I like maps. That's not why we put so many maps up there. This is just an image that I often use to talk about, pardon me for generalizing, lawyers' mentality, and at least lawyers of more like my generation. Many of us, I actually got this insight from talking to a friend who's a great trader, and he trades, do a deal at a time, and I think that's very much how we approach our profession, and let's call it the legal service industry has been operating at this moment. Because we often deal with remedial stuff, we try to keep things from really falling into litigation, letter of inquiry or investigation from the government authorities. Sometimes we get dragged in from the reputation side, something blow up or some executive did something they're not supposed to do. M&A also is very much a legal function, more often than it's at the back end. So it's always urgent. So it's a deal. We do deals, we measure ourselves, what we have done by what sits on our shelves. At least once again, for some of the lawyers who still put books on the shelves, or binders and closing binders. But from somebody who's, once again, constantly inside a large organization that is working with more than account receivables and inventories like payables, we're not just making that margin, you're actually making a long way of stickiness to work with your clients. How do you get them? How do you understand them? How do you get them to come back? How do you get them to buy? And all this stuff. You actually have to break things down. But what am I saying really to you folks and all of us who happen to buy music a song at a time today, or we get magazines, we're reading materials, sometimes free, sometimes in a different way. It's nothing new from what we're already doing elsewhere now. We don't have time to go into legal exceptionalism today, why law and legal profession is different. But that's a debate that has been going on. But once again, I want to say from my perspective, it is, by the way, a quick poll. Anyway, just a quick poll just to make sure we're on which page. How many have heard of and maybe read Richard Susskind? Good. Richard Susskind is my hero, a lot of people's hero. He has been early advocates of these things for at least 20 years, I would say. And one of his classic slides and image is how not just legal, all kinds of different services can be broken down from bespoke, tailoring, one of its kind. I don't even start with a template. I write from here in my experience, broad experience of things, and you pay me for my judgment and I solve your problem. And find ways to get paid for it, other than $1,500 an hour, right? But then he's going to standardize, systematize, package, and automate to what we call commodity work. We hear a lot of it. And a lot of people say it's either, because we have a tendency to swing on both ends. So it's something is either bespoke and it's only worthy of me. It's other people's problem. For me, it's bespoke versus commodity. It's not. It's actually somewhere whole thing in between. You look in the financial industries, accounting industries, increasingly healthcare industries. Of course, we can't simply compare India with Boston and New York. You go to Mass General, you have a very different operation. But sometimes people have to start partialing things. You can't have just all lawyers and all doctors and experts looking at you. You have to hand off things and you have to coordinate things. And just to make a long story short, I think we're running behind on time. The way I look at this, and just for imagery, it's Hollywood. Hollywood has been operating on general contractor, subcontractor, this model for a long time. And we may not want to be called general contractor, I'd rather be called General Counsel. But in fact, that is going to happen when people do break things, because when you break things down, there's something magical happening. Because after a while, when you do break things down, what are we all serving for? How are we lining up? And there's got to be a voice of customer. And bias that might be, the clients is the voice of customer. It might be the GC, it might be the finance CFO, it might be the CEO of this business, it might be the sales guy or R&D. They have to pull you, and sorry, this is the only hopefully pitch you're gonna have. You have to get yourself in gear, because for a long time the legal function has been spinning by itself. And there's a huge gap between business and law, just like we've been witnessing quite a bit of gap between IT and law. IT is going to come to a law rescue, right? But there's a huge gap. So we have to get these gears all lined up, and this is where the breaking up of the unbundling is going to help us to do it.
Probably my favorite slide, and one of my favorite cartoons. I love that one. So what you're saying, Dad, is that when a person has a problem, they call a lawyer like you to fix it. If you fix it, you get a lot of money. And if you don't fix it, you also get a lot of money. And I love that slide, or that cartoon, because it really focuses on what, in my view, is the fundamental disconnect right now in the provision of corporate legal services. And that is that clients aren't buying what law firms are selling. Law firms that are built on the billable hour are fundamentally selling their time, and their inventory is time. But if you ask a big corporation, what are you actually buying from your counsel? They're buying their longitudinal experience, the fact that they work across a lot of clients in a lot of different industries, or even within the same industry vertical, so they bring a perspective there. They are buying the fact that they may be a subject matter expert in a very, very specific area, whereas a general counsel, they're a bit more of a generalist. They may have just the ability to provide solutions or strategy above and beyond the internal capabilities of their own organization. They're not actually interested in just buying your time. Also why I like the song that Kenny played for you at the beginning. So it all starts with the idea that the billable hour is a conflict of interest. Conflict of interests occur everywhere, and you guys have come across them in your studies, and you'll come across them as you continue and in your practice as well. And conflicts of interest are not inherently problematic, but conflicts of interest need to be managed. And increasingly there is a focus on how much resources are actually going into the management of the conflict of interest that's caused by the billable hour. And we've seen a lot of things start to happen. So we've seen outside counsel guidelines that get into very, very granular areas like we won't pay for first year and second year associate time. We won't pay for more than one lawyer at a team meeting. We won't pay for more than one person to attend a deposition regardless of how many people you send there. And it started out with even more administrative and ministerial things like it's going to be a nickel per page of photocopying and not more than that, and really focused on the disbursement sides. But what I've seen is increasingly corporate clients, one of the ways they're exercising their purchasing power is by managing their law firms and saying, here is how you are going to staff, and here's how we're going to permit you to bill for your time. And if you think about that, there's not a lot of industries out there where the client actually dictates how the product is delivered. Nobody tells PepsiCo like how to mix their syrup. But that's happening right now. There's also an entire cottage industry right now of both electronic and human-based review platforms where your hourly timesheets don't go to your client, but they actually send it to a third-party vendor that scrutinizes your hourly entries and say, no, that meeting shouldn't have been an hour, it should have been 0.75, and we don't pay for like drafting emails and this, that, the other thing. And these companies, their basic business model is we will get more write-offs from your law firm than you will pay us, so we are actually cost positive. That's a lot of resources that are going into the billable hour, which is why you now see this talk throughout the industry about value. And what does value in legal services mean? So the Association of Corporate Counsel, the ACC, has their value challenge every year where they look at innovative relationships in the law firm and corporate relationships and highlight a few winners every year. You see the rise of alternative fee arrangements that get away from the billable hour and are trying to restructure how law firms and their clients work together. Some of which are true risk-sharing partnerships, and some are more the pendulum swinging the other way, where instead of the law firm saying, heads I win, tails you lose, the client is now saying that, and they're putting all of the risk back on their service provider rather than all of the risk on them. And look, there's no particular answer as to what value means in legal services. If you spend 15 minutes on a search engine, you'll probably come up with about 30 different answers, each one coming from a speaker that will tell you that it is definitively and unquestionably correct. But I think increasingly what we're moving towards is a relationship between the client and their external counsel where they're sharing in the risks, where each one has got a little bit of skin in the game, where clients are becoming more sophisticated. And this is something that this is a skill and a talent that they did not need to have under the paradigm of the billable hour. You didn't need to be able to scope out a matter. You didn't need to be able to articulate your strategic and business objectives. When you're doing a true risk-sharing arrangement, you need to be able to articulate why you are hiring your law firm in those terms and identify measurable milestones and deliverables that you're asking from the counsel. So it's a little bit of an education on both sides of the buy-sell equation, but you're increasingly seeing that happen, and that is changing the way that the legal services are delivered and the way that you partner with your outside counsel and share the risk. Kenny, this is a good one.
This is not a force of change. We will be really remiss if we didn't talk about change management. Bill and I may sound like we're drunk the Kool-Aid, and especially in a bespoke institution like this that feeds into another bespoke world of big law and other very interesting legal profession, legal service organization, what may call it. But there, in these organizations, that's precisely where the change is happening. I don't know whether you can see some of these. This is a classic. There are many variations of change management. If you're missing any one of these, you got frustration. If you're missing the ability, the capability, and for us, it actually means a lot about law, what we study. Some of the lesser spoken about law school, they're turning out students who does coding, who does process management, who does managing other various things, deal with data analytics. I wish, in fact, I'm very tempted to really take courses from those, because if I want to sound credible, more credible, right now I have to go partner with various people to do that. But if I want to be credible, I should really learn some of this stuff. And we may want to do that. And Bill needs to do much less of that. I'm technically a yellow belt, in Six Sigma, but I've never practiced. And if you don't practice, you're nobody in Six Sigma. So it's about changes. If you're missing the practical, you have to make things right. You got to meet people's vital interests. If you don't, you may not get the right start, and the whole thing just tank right in the beginning. If you're missing the vision thing, that's great, but it fizzles out sometimes because you need something to sustain you. And ultimately, you need some pressure. And these are your classic cases here. Now, let me just rattle off a few things that we just come to my mind when we prepare this of issues of change, resistance to change. Once again, I think I heard this from Richard Susskind, but I'm sure he got it from someone else perhaps. It is difficult to persuade a room full of millionaires to change, right? If it's not broken, why fix it? I actually like to call it incumbent's dilemma, because I spent about 7-8 years for the company you may not remember called Eastman Kodak Company that used to sell film and paper, which it's like printing money, literally 90+% margin in one of their best products. And that's not just a small product, it's most of their product lines. And when you are an incumbent, and they are innovators, they made, up until recently, all the the charge couple device behind your older version of digital camera. They made all that stuff. They have a finger and everything, but they can't change the thing that killed the goose. They can't do that. They can't just, HP and other people, they're much better. They split the company. Alphabet, Google may have other ideas. They try to keep that idea going, so they jump from one tall building to another tall building and keep on going. Not everybody can do that. The first movers advantage we always hear about, right? But first movers have risks as well. And too often, first mover risks just yield what I call the first imitator's treasure. And that's a very reasonable thing. I'm not saying people who don't change are not right. Well, sometimes, as we see a lot, there's a lot of apps looking for a solution. And that's happening a lot elsewhere too. The key thing I mentioned, I talked about, is the disconnect between the IT world and the legal world. That's contributing a part of that. Not all of us really want to do preventive law all the time unless you've been sitting inside a place where you feel frustrated. You really want to do preventive law. and capabilities in other some of these issues. Now, there are some hopes. There are people who are investing. There are people, some law firms, I call it acqui-hiring. They started hiring a consulting arm, the Nix Laws of the world, and they're starting to really, but a lot of it is really hedging, because that's precisely where they want to be. They want to be the first imitator. And enough of a foot maybe to call themselves innovator as well. So this is just a reality of change, but we should really keep that in mind. Let me move on to, once again, I need to apologize. I'm going to, in the interest of time, I'm going to play you a song. The last song was from the Bar and Grill singers, which I like very much. I need to give them credit for it. This song comes from a much, this is really nothing in comparison, but I want to play it because it's an answer, my answer to the I'm Billing Time song. It is, the lyricist is a total amateur, but the singer, Jing Liang, there's nothing amateurish about her. She's a second year law school at UT Austin. Apologize, I'm also going to cut out the first stanza because I'm going to try to save some time. We're going to try to have some conversation now. You can still get that online.
Well, and now you see what happens when lawyers try to be lyricists.
We have version 2 coming out.
So we covered a lot of things, very quickly. We hope that at least the overview gave you a little bit of flavor of things that are going on. But by all means, we wanted to open it up for questions, and we can hit on anything and or everything that you find curious. Sure.
I know that litigation has a lot of algorithms that cut through the diligence report, and I know that General Counsel doesn't have a lot going on, especially the really specialized fields like executive conferencing. Do you think those computer programs are in the works?
I know those computer programs are in the works. So, for example, there's a program out there called Diligence Engine. That is really focused on the corporate M&A diligence side that, your standard diligence report is going to be looking at, a few certain sort of key terms, right? Like change of control, term, things like that can go through and can extract these terms using natural language-based analytics. In terms of the executive comp space, I'm not specifically familiar with that, but I wouldn't be surprised if somebody was working on it. As Kenny was kind of pointing out, there are institutional barriers, right? So the seller has to be willing to put their data up into some kind of data room that allows a machine engine to go in there and read it. And we're still, right now today, In my experience, most sellers don't like that idea because they feel like their stuff is going to go far and wide. Whether that is truly justified and how long that kind of knee-jerk resistance will continue to exist, I don't know. But I think that there are absolutely technologists that are looking at these problems because, as with all of these things, they're looking for the low-hanging fruit. Like, what is the area where very high-paid associates are doing relatively ministerial tasks that are very time-consuming, and that's within the unbundling. That's the bullseye, right? Like, that's your low-hanging fruit that you want to automate.
But what if it communicates that that's what junior attorneys are supposed to do, so they can learn what the trade is? I mean, if these things are all being replaced by machines, then how are junior attorneys ever gonna become like partners or anything?
I mean, I don't know. I query, and I'm interested in Kenny's perspective on this. I don't mean to dominate, but I'm curious whether going through like 500 boxes in a warehouse in Des Moines and pulling out your change of control provisions actually teaches you to be a partner. I think that the end result of that, right, where you actually have kind of a diligence report and then you sit at that meeting with the acquirer and you say, all right, you know, these 50 change of control provisions are fine, that's not a concern. This group of 20 are a little bit of concern, and having a seat at the table to hear that discussion and how are you going to strategize around that, that's where you're actually developing your strategic skill. And the value that they bring to the table, you know, pecking for particular words or provisions.
I think the larger question though is where's the training going to come from? And I don't think we have the answer yet. Hopefully some from here, but also are the law firms going to take responsibility for the training? Will law school students do something else first before they get on the law firm track, whether it's working at a United Lex or one of these companies that does it? Importantly, in lieu of thinking of it as machines replacing what you associates used to do, even associates from Harvard Law School, I'd be more worried about non-lawyers replacing what associates are doing, because they might do that at a much lower cost and able to do so because their loans won't be as great. I mean, you guys are at Harvard, so you're not in the same situation as, you know, the 70% of law school grads right now, but I throw this question out back to maybe Kenny and Bill, because you were a senior associate at Paul Hastings. How are these great minds going to get trained in strategic thinking, and you know, what will the future hold for them?
This is very apropos. Bill and I were sitting in, I forgot which city we're sort of running around, Will Whirlwind sort of circuit here. I think Chicago, where we're sitting in a beautiful conference room at a law firm. Very entrepreneurial one, but by no means small at all. They're getting to be quite big. And the question came up, you know, this litigator is going to say to his associates, say, so-and-so, you know, John, Jane, you're just going to build 2 hours on this. So we know that you probably turn your wheels like crazy. And then the question came up. First of all, very quickly, before I forget, you won't be replaced by a machine. I won't be replaced by machines, because there's the compassionate, the conceptual, and the creativity stuff that we think most machines. And in fact, in spite of what Watson and all these things are calling themselves to do, I think they're going to take a while. There's a lot of issues to work through. You still have to teach them. And we have seen the curve. It's going to go like that. And I believe it. But it's going to take a lot of effort. And Michelle's point is great. Actually, the unbundling part's going to unbundle into a lot of non-lawyers. And you take the medical profession, it will be very good. It's not just paralegal. It's other people who are. But get to your point very quickly. I thought about, Bill and I just said that, well, what do law firms do? They need to train their younger associates, right? For what? Just like some of the people in some developing country, why do they have kids? They love each other, but they also need people to go feed them when they're old. So you're creating it's a bit of a family tribal thing there. Now, there are some law firms that may say, fine, I'm going to put all this stuff into an IP system, knowledge management system, and this will be our thing, and then our partners will own it forever. And then we'll sell it, just like IBM and PW and all these guys do with various assets they have. But people is going to remain to be part of it. I don't see it's going to be simply. How do you train? I think in that conference room, the one thing that we commented about is, well, you still have to throw a junior associate into something and let him or her find a long way around. But you're going to have that little expert system sitting there and giving you some pressure. The expert system already has the answer, but you're going to have to go find it. And from time to time, you may actually beat it because you actually have you plug into other data that the expert system might not have been taught to do that yet. So there's going to be a little bit of what I call gym exercise of competing between. You're going to have a lot of Kasparov versus Deep Blue for training purposes. That's how I like to think of it. Yes, sir.
So I was interested in the description of how people are saving money by creating more attorney positions in-house and then saving the $1 million to $750,000. But I guess the question is, how is that specific to now, right? It seems like that kind of analysis could have happened 15 years ago, 20 years ago, 30 years ago, as long as there was a substantial cost differential between an in-house attorney outside law firm. And
Correct.
What changed about that made it so much more desirable, or is it just that people realized they've been making mistakes for however long?
So here's my perspective. First they came for the accountants, then they came for the auditors, and now they're coming for the lawyers, right? All of these professional services functions at one time or another were considered highly skilled, very professional risk management functions that the corporation was very, very, very scared to put cost pressures on. And that allowed them to kind of operate and develop and live in an area. And in the same way that you saw massive consolidation in the accounting firms, and now we've got the big four, and we used to have the elite eight, and then whatever kind of preceded that. Part of it is simply them waking up to their own purchase power, and that they allowed irrational pricing to exist. I think the other thing to keep in mind is you want to have, from a corporation standpoint, there's a real expense to hiring a full-time equivalent. There's recruiting costs, there's maintenance costs, and it's not that easy to exit a person, and there's a lot of costs associated with that as well. So you want to be satisfied that you have enough repeatable work and that you've got the right talent in place to justify the FTE. And then the third thing, it's kind of, I don't know if it's different or the other side of the same coin, is the legal function is, setting Tom Sager and what he did at DuPont aside, generally not a profit center, right? So it's generally difficult when you're the general counsel of a corporation to make the argument as a cost center that you should grow. Now, people are making this argument, and it's getting more and more reception and traction internally, but it's not universal, and this is also why I kind of said, it's the accordion, right? It goes one way, it goes the other. So you have some of these institutional barriers that push the other way as well.
I have two quick comments on that. Number one, if you talk about 30 years ago, when once again, I'm dating myself, in 1986, Cravath, one of these top law firms, they doubled the salaries of associates into a whopping $60,000. That's 1986, and now we sort of know what big law pay their first-year associates. It's already one more zero behind that. And then I talked to some of the more seniors who started practicing in 60s, whatever, and they got paid half of that. So I think sometimes the law firms might have, legal industry might have backed itself into a little bit of corner. Kodak wasn't charging that much per roll of film. They're run down, they keep the efficiency down to make that margin. So that's one element. But nonetheless, I actually think that's a relatively speaking, short-term phenomenon, because you go legal process outsourcing, business process. It's a race to the bottom. At the end of the day, it's perfect competition to the extent it can be, like the financial industry. What my aspiration is It's actually will free up the lawyer, not only all in-house lawyers say, not just because we want to be counselor, we want to be conscience of the company and all that, but not just, we actually want to go in there and say, this is risk management, but what is the opportunity? And question the business and not go toe-to-toe, but really have a more complete picture. And that's what I think all this stuff is going to bring us into. Now, whether it could be more lawyers, fewer lawyers, I think you ask the farmers, how many farmers are there today? That's just the way things are. We have to accept that. Not in our generation. It's not going to big bone like that, but it's where we're heading.
When you talk about measuring the value of legal services and focusing on that, what kind of data and metrics are we looking at, if any? Like, is there particular data that you would want that would be ideal in figuring out how to evaluate legal services? Or is there a particular output per se that we're trying to measure?
Sure. You want this one or you want me? All right.
Did you get a shot first?
Right now, state of the market is most people are starting out with a retrospective analysis. So they're kind of trying to identify what they consider to be analogous matters and figuring out what it cost before. And there's a few different ways that you can look at it. If you've got a particular transaction, you might look at it with the investment banking model and saying how many points or what percentage of the deal value are we spending on legal services. So if you are in the business of buying companies like a private equity shop, you might say, all right, as a percentage of deal value, we're normally spending X percent on things. And you can apply that to M&A, you can apply that to counseling, you can apply that to a lot of different things. In terms of the biggest macro metric within a corporation, I think that you're looking at legal spend as a percentage of top line revenue. And it's kind of like, okay, if we want to sell X number of dollars, how many cents on that dollar goes to this legal sort of a support function. I think that the next cut that I'm seeing corporations take is they're looking at value generative versus value protective. And when you do that analysis and you divide your legal work into those two buckets, you spend a different percentage of total value on or total cost or amount at issue within those. So that could be an acquisition is kind of the easiest example. An acquisition would be value generative legal work, whereas a litigation or defending against a class action would be value protective. And they're looking at that. I think taking the next step beyond that and actually saying, okay, hey, law firm, this is what I'm going to pay you, is when you're getting into a little bit dicey territory. I have seen that happen, but that is, again, an artifact of the buyer's market that we're in, because normally we're not accustomed to, at least in North America, going in and saying, I know you're saying, $2 a pound for those organic apples, but no, I did a historical analysis and it's $1.25. We're not used to naming our own price. Corporations are starting to do that a little bit, but mostly it is a retrospective analysis based on historical data. Does that help a little bit?
Yes, sir.
I have a curiosity about document assembly softwares. I'm from Brazil, and a few years ago I decided to start this business related to document assembly. And later we realized that the Bar Association prevent this sort of things of happening in Brazil. But this is something that makes a lot of sense, especially when you're talking about more standard agreements like non-disclosure agreements or term sheets and things like that. And our idea was to tie this to the website of our law firm so private equity funds could enter for free and download a very specific non-disclosure agreement. And then the idea is we'll have access to that information and we could contact them and start business. So my question for you is, why this is not happening fast as one would expect? Since we have the software, it's easy to make that forms into the website. I mean, all the technology is available. Is this like a cultural barrier, or I'd like to have your comment on
Well, you answer your own question. It is. I've been seeing contract management, for example, and which is a lot more involved than just templates. You're talking about alternative terms, analysis of backup provisions, and then the back end of it for reminders and all this other stuff. For example, that's a very basic contract management. They've been around for, probably 20 years too, potentially 15. I've been, in one of my companies, I've been waiting and waiting and waiting, in the region to start my own, but they say wait for the headquarters. It's a lot of cultural. Remember, it's not. That's something that I think we touched on. It's not just software. It's not just, you have to actually have touch points. You have the racing chart, how people hand out relationship. In some of the Chinese organizations, they say, oh, it's a contract.